Hello, welcome to Timmy Matt Law with me, Mr. McLaughlin. We are going to focus on the concept of a duty of care in this video. And this is a really fundamentally important concept when it comes to tort law, which is an area of law under the civil law. So obviously we're going to move away from the criminal law and we're going to be looking at the tort law context. And because of that, I think it would be useful for me to give you a short introduction into tort law just so you can grasp some of the basics. So a tort literally means a wrong, and it will be a wrong that can lead to a claim for compensation. There are lots of different torts. You're going to study 4 of them as part of your A-level, and we've got the tort of negligence, occupier's liability, nuisance, and vicarious liability. Those torts may not mean too much to you now, but of course they will do in the fullness of time. This is by no means an exhaustive list of all the torts that do exist, but indeed these are the ones that you are going to need to focus on. Now, the parties involved in a tort case are the claimant versus the defendant, and that represents just a little bit of a difference between the parties involved in a criminal case, where of course you've got the prosecution and the defence or the defendant. Here you've got the parties in a civil tort law case, claimant versus the defendant. And it's the claimant that's making the claim against the defendant. The claimant feels that a wrong has been committed against them, they want compensation, and therefore going to make a claim against the defendant. And as such, the burden of proof is on the claimant to prove their case. They have to work just a little bit harder in order to prove their case against the defendant in order for their claim to be successful. The standard of proof in a civil tort law case is on the balance of probabilities, and this again represents a significant change away from the criminal law, where the standard of proof is of course beyond all reasonable doubt. In the tort law context, it's on the balance of probabilities. So think of that finely tipped weighing scales, and it's up to the claimant, or indeed the claimant hopes, that they can tip the balance in their favour in the hope that their case will be proved according to the balance of probabilities. Much lower standard of proof in tort cases in comparison to the standard of proof in criminal cases. And then finally, the remedies involved in a tort case include damages, which really means money. That's what the claimant normally wants. They want money from the defendant, and it comes in the form of damages. It can also be the case that a remedy in a tort case is an injunction, which essentially means that the judge will order the defendant to stop, or indeed instruct the defendant to actually do something. A good example of that, and it falls under the tort of nuisance. If you've got a neighbour that is playing their music too loudly, an injunction may actually order the neighbour to stop playing music, or indeed to turn their music down. And you can get damages being awarded and indeed an injunction happening as the outcome in the same case, or it can be one or the other. But do be aware that they can be applied both at the same time. So that's your introduction into tort law. Let's move straight into, more specifically, the concept of a duty of care. Now again, let me just kind of ease you into this particular concept by giving you just a little bit of context. Now, this concept of a duty of care is particularly important for us at this stage when it comes to the tort of negligence. That's the tort that we're going to begin in studying right now, okay? So, when it comes to negligence, which is essentially where someone doesn't take a sufficient level of care in doing something, that can lead to liability for physical injury and damage to property, or indeed physical injury or damage to property. Now, if you want to make a successful claim, should you have suffered from physical injury or damage to your property, or both, you've got to establish whether a duty of care exists. And that relates to this particular concept specifically here. Does the defendant owe the claimant a duty of care? Once you've determined that the defendant does owe the claimant a duty of care, you've then got to address these other 2 principles here. Has the defendant breached their duty of care to the claimant? We'll look at that in a future video. And indeed, has the breach by the defendant caused damage to the claimant. And again, we'll look at that in a future video. So our focus is very much going to be on the concept of a duty of care, which yes, does appear pretty much in all of these principles that you have to address, but particularly this first one here, which is what we're really going to focus on. Does the defendant owe the claimant a duty of care? Well, in order to establish whether the defendant owes the claimant a duty of care, there are two tests that have been put forward as a result of case law in order to determine whether a duty of care actually exists between the defendant and the claimant. So, the first test is known as the Neighbour Principle, and this directly stems from the case of Donahue versus Stevenson 1932, and this case is often given the nickname of the snail in the ginger beer, okay, or the snail in the ginger beer bottle case. So you can refer to it as that case in inverted commas, but of course do get in the correct title as well, which is Donahue versus Stevenson in 1932. So the circumstances of this case, well, you had two friends that had walked into a bar. One of the friends ordered a beer at the bar and they both sat down at a table, and indeed the other friend grabbed the beer and actually poured it on some of that ice cream. So they're going to have some ice cream with some ginger beer on top of it as a bit of flavour, if you like. When they were eating some of the ice cream, they were happily eating away at the particular ice cream with the ginger beer, and then they decided to pour more ginger beer on top of the ice cream. And it was at that point that a decomposing snail fell out of the bottle and into the ice cream. And therefore, the claimant suffered some shock, they felt sick, and they decided on this basis to make a claim against the manufacturers of the beer bottle. Now, fairly straightforward case, it seems, at face value, except that the manufacturers went about arguing that they didn't owe the consumer of their product, the consumer of the ginger beer, a duty of care because the friend who had bought the ginger beer bottle didn't actually consume it. She'd given it to another one of her friends, and it was she who had suffered from the shock and illness as a result of the decomposing snail. So the manufacturer tried to argue, look, we don't owe a duty of care to people who consume our products. Maybe we owe a duty of care to people who buy our products, but not necessarily to those people who consumed our products. So they're really trying to exploit the difference between the person who actually consumed the product and a person who actually bought the product. Well, the outcome of this case was that the judge was not having the argument of the manufacturers, and they placed the duty of care on the manufacturer for anyone who consumes their products, not just for someone who buys their products, but for someone who actually consumes their products as well, okay? And actually that's a fundamental principle of our consumer law. It offers us quite significant protection when it comes to all of us consuming products. Manufacturers have a duty of care to those people who consume their products, not just who buy them. Stemming from that case, you had Lord Atkin, the judge in the House of Lords, actually outlining the Neighbour Principle, which can be used to apply in order to see if a duty of care does exist. So here's what he said: you must take reasonable care to avoid acts or omissions which foreseeably could injure your neighbour, okay? So it could literally mean your neighbour, as in your next door neighbour, but actually Lord Atkin was referring in a broader sense to who your neighbour is. So we've got clarification here. Who is thy neighbour? Anyone who is closely and directly affected by your actions, that you ought to have them in your contemplation, that you ought to be thinking about them. So if you do anything, or if you fail to do anything, and you know that the consequences of doing something or failing to do something can affect someone who is closely related to you or directly related to you, then you should have them in your mind. You should look to take care of that person so they don't suffer any adverse effects from what you're doing or not doing. And that's the Neighbour Principle. And that works really well in terms of establishing a duty of care in a huge number of cases, until judges started to discover that such was the diversity of cases and indeed cases involving different levels of fact. Therefore, a more stringent test was required following the Neighbour Principle. Now, the Neighbour Principle has worked well, indeed it continues to work well, whereby cases are fairly well established, or at least the matters involved in a case are fairly well established. But what about if you get a rather unique or novel case when there may be no previous precedents that have been set? And this is where we get the second test in order to establish whether a duty of care exists. And it's known as the Caparo three-part test. It comes from the case of Caparo versus Dickman, 1990. And as I've just said, this particularly applies when no precedent has been set. It's a rather unique case. And indeed, a more stringent test needs to be applied rather than just relying on the more interpretive, if you like, Neighbour Principle. So, in the case of Caparo versus Dickman, you had a company, Caparo Industries, who felt that Dickman, the auditors of some accounts, had actually gave them some false information in relating to their purchase of a company. So Caparo Industries actually wanted to take over a company known as Fidelity PLC, and they argued that the accountants, the auditors of the accounts, had actually accentuated the profitability of Fidelity, okay? And because of that, Caparo Industries felt that they suffered a loss from that particular transaction. So that was the nature of the case. The more important thing relating to this case is, of course, the test that stems from it. So I wouldn't be so obsessed about knowing the facts so much of the case of Caparo versus Dickman, more indeed in this context, the particular test that stemmed from it. So let's go to the first part of the Caparo three-part test. So part one, damage must be reasonably foreseeable. Now this test is known as the foreseeability test. Hence why I've highlighted the word foreseeable here. It's all about foreseeability. So damage must be reasonably foreseeable. This is an objective test, and you've got to decide, objectively speaking, would the defendant have been able to reasonably foresee damage that would be caused to the claimant as a result of their actions. Now, as a way of highlighting this, we've got the cases of Langley versus Ray and Kent versus Griffiths. So let's look out for, would a reasonable person, could they foresee that damage would be caused by their actions or omissions to the claimant? So in the case of Langley versus Ray, 1998, you had a police officer who was speeding after an alleged criminal, or at least someone who they felt that they needed to apprehend. And the person who was speeding away from the police officer decided to speed up. And of course the police officer then, logically speaking, decided to speed up too. And that led to an accident for the police officer. So the police officer actually brought a claim against the alleged criminal on the basis that the criminal should have had the foresight that they would cause damage, indeed the accident, to the police officer. If the the criminal, speeds up, then of course the police officer is going to speed up too. So surely the criminal must have been able to foresee some sort of damage to the police officer. And indeed, on that basis, the police officer's claim succeeded. It was found that the criminal must have been able to foresee that damage would be caused to the chasing police officer, the claimant. In the case of Kent versus Griffiths, 2000, this is where you had an asthma sufferer who suffered from an asthma attack, and the doctor who was accompanying the asthma sufferer who'd suffered from the attack actually rang for an ambulance. The ambulance, though, took 40 minutes to arrive. And indeed, it didn't seem that that communication, that information, was communicated to the patient, the asthma sufferer, and therefore they suffered a more serious injury. They had a heart attack. Now, the doctor who was helping the asthma sufferer did give evidence citing that they would have actually told the asthma sufferer to get to hospital as quickly as they could, rather than waiting for an ambulance to arrive, if they had known that the ambulance was going to be late. But of course the doctor didn't know that information, and it was found that the ambulance service had a duty of care on the patient to tell them that they were going to be late, and therefore they should get themselves to hospital as quickly as possible. And if that had happened, they may well not have suffered from a heart attack, a more serious condition as opposed to the asthma attack. And it was found that the ambulance service did owe a duty of care to the patient in those particular circumstances. It was reasonably foreseeable that the asthma sufferer would suffer from a more severe condition. So that's the first part of the Caparo 3-part test. Let's move on to the second part, and this second part reads, was there sufficient proximity between the parties? This, of course, is the proximity test of the Caparo 3-part test, hence why I've put it in a highlighted text, and this really refers to closeness. That's what proximity means. Was there sufficient closeness? Now, closeness can come in the form of time, space, or relationship. Was there sufficient closeness between the claimant and the defendant in terms of time, space, or relationship? Now, more obviously, we're talking about physical closeness here. Are they physically close together? And if you are physically close to someone at the same time, therefore, you may well have a duty of care to that person. That's fairly obvious. But with modern technology as it is at the moment, and indeed probably forevermore, you don't have to be physically close to someone to owe them a duty of care. You could owe someone a duty of care and they could be on the other side of the world. So physical closeness is only one aspect of proximity. Where you do have physical closeness, of course, proximity is easy to determine. Sufficient proximity is more likely to be present if indeed there's a physical presence between the claimant and the defendant, but equally do be aware they don't have to be physically in the same space, if you like. They can be on the other side of the world. So, case examples regarding sufficient proximity. We've got the case of Bohr versus Young, 1943, really tragic case in the case of Bohr versus Young. This is where you had the claimant who had heard a road traffic accident, apparently at the point at which he stepped off a tram, and decided to go and see the aftermath of the road traffic accident. It was actually a motorcycle accident. Now, the important thing to know is that the claimant was pregnant at this particular moment. So she heard the road traffic accident and decided to go and take a look. And at seeing the aftermath of the accident, which was clearly not very pretty, she suffered from shock and miscarried the baby. She therefore sought to make a claim against the person who she considered to be was at fault for the road traffic accident. However, her claim did not succeed as there was not sufficient proximity between her, the claimant, and indeed the defendant whose fault it was for the road traffic accident. And that was because Mrs. Bohr decided to go and see the road traffic accident herself. No one had forced her to go there. She didn't have to go there. She had taken the conscious decision to go and see the aftermath of the accident simply by hearing the sound of the accident. And because of that, there wasn't sufficient proximity, not sufficient closeness between claimant and the defendant, and therefore her claim failed. Rather tragic, it seems, but I think you can get the logic of that. She didn't have to go there and witness the horrible scenes that she did. And then the next case example, we've got McLaughlin versus OBrien, 1982. This is where you had, again, another tragic set of circumstances, a really serious road traffic accident whereby the husband of the claimant and 3 of her sons were involved. And indeed, I think this was a road traffic fatal accident. So really, again, horrible scenes that the claimant would have to deal with here. But the claimant herself was not involved in the accident. She heard about the accident as a result of another one of her sons who was in the car following their siblings who were involved in the accident together with their father. So the son who was not involved in the accident went home, told his mum about the accident, and at that point his mum, the claimant, went to the hospital and saw her loved ones, her other sons and husbands, in rather a mess. Clearly severely injured, and this caused her shock and indeed depression. And she sought to make a claim against the defendant, the person who had caused the road traffic accident, for the psychiatric injuries that she had suffered from. And indeed, her claim was successful. And that's because it was considered that she was wrapped up, if you like, in the aftermath of the accident. Of course, it makes logical sense. If you know your loved ones are in an accident, you go to the hospital to see them. And it just so happened that bad luck, more bad luck, came towards the claimant, and she saw her loved ones in rather a state. And therefore, the judge ruled that there was sufficient proximity, sufficient closeness between the claimant and the defendant, because it's logical, isn't it? It's perfectly reasonably acceptable to see that a loved one would go to a hospital and indeed try and see their loved ones. And it just so happened that the claimant stumbled upon them. So there's the second test of the Caparo three-part test. Let's go to the third test, or the third part of the Caparo three-part test. And this asks, is it fair, just and reasonable to impose a duty of care on the defendant with respect to the claimant? Okay. Now, this is known as the reasonability test, hence the fact that it's highlighted. So we've got foreseeability, proximity and reasonability. It is worth remembering these statements so you can explain them in full, but you may hear the shorthand version of foreseeability, proximity and reasonability. Okay, so is it fair, just and reasonable to impose a duty of care on the defendant? And this is recognised to be a policy test which asks what is best for society as a whole. This is where you have a judge thinking a little bit broader away from the case, because of course the judge may be setting a precedent which could apply in the future to all similar cases, and therefore judges are very mindful, courts are mindful, they're wary not to open the legal floodgates. You don't want to make a decision as a judge with respect to liability which will stuff the courts full of other future claims. So therefore courts and judges are just a little bit choosy in terms of successful liability when it comes to the cases that will be successful in terms of the claimant's actions, because you don't want to have an indeterminate number of claims being made by an indeterminate number of people in the future. The legal system will just clog up and will not work successfully. So courts are mindful of that. They're also mindful to protect the successful operation of public services. And I'll go through these cases here, and that will highlight that particular statement. So the first case we've got is Hill versus Chief Constable of West Yorkshire Police, 1990. And this is where the claimant was making a claim against West Yorkshire Police for having not successfully detected the Yorkshire Ripper, and indeed the crimes and who the Yorkshire Ripper actually was, who was responsible for these crimes. And the claimant was actually the mother of one of the victims of the Yorkshire Ripper, who was obviously a serial killer. So the mother's obviously arguing that you should have caught the Yorkshire Ripper quicker before my son's death. Now, the claim actually failed because the judge ruled that that would place an undue amount of strain on the police. The police, of course, have a tough enough job in order to detect criminals, and they shouldn't be found liable where they cannot detect criminals and indeed apprehend and arrest them in a quick enough time before other future crimes are committed. Now, if that claim had been successful, the judge ruled that the police service would have operated on a more defensive footing, if you like. They wouldn't have gone after criminals as aggressively as they would perhaps have liked. And equally, all the past cases would have been reopened, the floodgates would have been reopened, whereby other claimants may have cited that, you didn't detect my relative's killer, if you like, quick enough, and therefore I'm going to make a claim against the police. So that you can see why the judge is apprehensive in terms of making that particular claim succeed against a fundamentally vital public service, which of course the police is. And the next case, we've got Mitchell versus Glasgow City Council, 2009. And this is where you had really a horrible situation involving two tenants in some council flats. And one of the tenants, who seems to be a horrible individual, was abusive towards one of their neighbours. Now, the neighbour complained about this abusive tenant, and the council, Glasgow City Council, who was effectively the landlord for these flats, decided to interview the abusive tenant to find out what they were doing and really to kind of issue some sanctions against them. Now, having had that meeting between Glasgow City Council and the defendant, not the defendant, and the abusive resident, the council essentially let the abusive tenant go to carry on about their normal business, but within an hour, the abusive tenant had actually killed the neighbour who had complained against them. Now, the claimant in this case were the relatives of the abused neighbour, the eventual victim who had been killed, claiming that the council should have notified the victim sooner, having had the interview with the abuser of their relative. It was ruled that the council didn't owe a duty of care insofar as notifying the victim that they'd had the meeting with the abuser, whilst the abuser may have gotten very riled and deliberately targeted the person who had complained against him. It wasn't up to the council to offer that sort of protection as the landlord. Maybe that would be a police matter, but it's not up to the council to predict future criminal behaviour, and therefore the claim actually failed. Now, having gone through the Caparo three-part test, it's really important to note that the answer has to be yes to all three parts of the test, so it all has to be satisfied. And really, this is the stuff that you must have under your belt. You must remember it to deliver successful answers when it comes to determining liability for physical injury and damage to property under the tort of negligence. I'm just going to throw this little tidbit in here right at the end though, because it seems that the law is developing. And that's a rather obvious statement for me to make as a law teacher. Of course the law is always developing. It always does. Having said that, I've caught sight of two recent cases, and I speak to you in 2020, of Robinson versus Chief Constable of West Yorkshire Police 2018 and Steele versus NRAM Limited 2018. I'm not going to go through the detail of these cases, but do look out for them, and I'll probably give your teachers a bit of a nudge to look out for them too, because it seems that the law seems to be steering us away from the Caparo three-part test. Now, I wouldn't worry about that so much at the moment, but it may, in the years to come, maybe in the next exam series or the next few, tweak our appreciation of what a duty of care is and how it should be applied because of these two cases. I don't think we fully understand the ramifications of these cases just yet, but it's useful for us just to keep an eye on whether judges want us to move away from the Caparo three-part test. So just keep an eye on the consequences of those two cases. Hope that was useful for you. Thank you very much.